I never thought a simple driveway dispute would consume over a year of my life. But that's exactly what happened when Brenda Wilson moved in next door and was appointed to the Oak Ridge Estates Homeowners Association Board. My nightmare began on a crisp autumn morning when I found her SUV deliberately parked across my driveway, blocking me from leaving for an important client meeting. Little did I know this was just the beginning of a 400-day battle that would ultimately end in a courtroom with Brenda facing criminal charges. My name is Henry Fitzgerald, and until Brenda came along, I'd been living peacefully in Oak Ridge Estates, a quiet suburban community in Fairfield, Connecticut, for nearly 7 years. I'm a software developer who works primarily from home but occasionally needs to meet clients in person. I'd always maintained good relationships with my neighbors and followed all HOA regulations to the letter, even the ones I found ridiculous, like the rule specifying exactly which shade of beige our mailboxes needed to be painted. The morning of October 15th, 2023, changed everything. I had an 8 a.m. meeting in downtown Stamford with a potential major client. I'd prepared for weeks for this presentation, and it could potentially double my annual income. I'd set my alarm for 6 a.m. to ensure I had plenty of time to prepare and make the 30-minute drive. When I stepped outside at 7:15 a.m., coffee in hand and laptop bag slung over my shoulder, I was met with an infuriating sight. A gleaming white Cadillac Escalade was parked directly across my driveway, making it impossible for me to back out. The vehicle wasn't just partially blocking my exit, it was deliberately positioned to maximize obstruction. I immediately recognized it as Brenda Wilson's SUV. She'd moved into the neighborhood just 3 months earlier and had quickly made herself known by nitpicking at everyone's property maintenance. Within weeks, she'd somehow maneuvered her way onto the HOA board, despite being a newcomer. At 52, with her perpetually highlighted blonde bob and designer sunglasses, Brenda epitomized the stereotypical suburban Karen. I rushed over to her house and rang the doorbell repeatedly. After what felt like an eternity, she opened the door in a silk robe, coffee cup in hand. "Brenda, your car is blocking my driveway. I need to leave for an important meeting right now," I said, trying to keep my tone civil despite my rising anxiety. She took a slow sip of her coffee before responding. "Good morning to you too, Henry. Is there a problem?" "Yes, there's a problem. Your SUV is blocking my driveway completely. I need to leave immediately." Brenda gave me a cold smile. "Oh, I'm sorry about that. I had some friends over last night for a little get-together, and one of them must have parked there." This was clearly a lie. I knew her car well, and there had been no party the night before. My neighborhood is quiet, and I would have noticed. "Brenda, it's your Escalade. Could you please move it now? I'm going to be late." Her expression hardened. "You know, Henry, the HOA has received several complaints about your property lately." This was news to me. "What complaints?" "I've followed every rule in the handbook. Your grass was half an inch too high last Tuesday. Your garbage bins remained visible from the street for over 3 hours last collection day. And that bird feeder in your backyard isn't an approved design." She took another sip of coffee. "The board will need to discuss these violations at our next meeting." I was dumbfounded. "Brenda, this has nothing to do with my driveway being blocked right now. Please move your car." "I'll move it when I'm ready. I need to finish my coffee and get dressed first." With that, she closed the door in my face. I stood there in disbelief for a moment before pulling out my phone to call a rideshare service. While waiting, I snapped several photos of her vehicle blocking my driveway and sent a quick email to my client explaining that I might be running a few minutes late due to an emergency. By the time I returned home that afternoon, Brenda's SUV was gone, but my frustration remained. I decided to document the incident and sent an email to the HOA board, detailing what had happened and attaching the photos I'd taken. I received a brief, dismissive response from Gerald Thompson, the HOA president, stating that parking disputes between neighbors should be resolved amicably without board intervention. The next morning, I again found Brenda's Escalade blocking my driveway. This time, when I knocked on her door, she didn't answer, though I could clearly see her moving around inside through the front window. I called the non-emergency police number, and an officer arrived about 40 minutes later. Officer Mike Reynolds was sympathetic, but explained that since this was a private community with HOA-governed streets, there wasn't much he could do beyond documenting the incident. If this continues, you might want to consider civil action, he advised before leaving to knock on Brenda's door himself. Miraculously, she answered for him immediately and moved her vehicle with profuse apologies about forgetting it was there. The officer gave her a warning about blocking access to private property, but couldn't issue a citation due to our HOA's jurisdiction over the streets. This pattern continued for weeks. 3 or 4 mornings a week, I'd find my driveway blocked by Brenda's Escalade. Sometimes she'd move it quickly when asked. Other times she'd make me wait for hours or simply not answer her door. I documented everything meticulously: dates, times, photographs, and records of my attempts to resolve the situation. By December, I'd filed multiple complaints with the HOA board, but Brenda's influence was evident in their responses. Gerald Thompson, the president, seemed increasingly irritated by my persistent complaints about trivial matters. What was trivial about being unable to leave my own property? I consulted with Gabriella Edwards, an attorney who specialized in property disputes. She was a striking woman in her late 30s with an impressive track record of standing up to unreasonable HOAs. After reviewing my documentation, she shook her head in disbelief. "This is clear harassment, Henry. The HOA may have authority over certain aspects of the community, but they can't allow one homeowner to repeatedly block another's access to public roads," she explained during our first consultation. "We have several options here. We can file for a temporary restraining order, sue for harassment, or even pursue criminal charges for intentional obstruction if we can prove malice." Following Gabriella's advice, I first tried sending a formal cease and desist letter to Brenda, with copies to all HOA board members. This seemed to work for about a week. Then, on Christmas Eve morning, I found not just Brenda's Escalade blocking my driveway, but also a large rental moving truck parked perpendicular to it, making it absolutely impossible for me to leave. I was supposed to drive to my parents' home in New Haven for the holidays that afternoon. When I confronted Brenda this time, she was standing in her front yard supervising 2 men who were unloading holiday decorations from the truck. "Merry Christmas, Henry," she called out with fake cheerfulness. "We're just setting up for the HOA Christmas contest. The truck will be gone in a few hours." "Brenda, this has gone beyond ridiculous. You know exactly what you're doing." Her smile vanished. "What I'm doing is bringing holiday spirit to our community, which is more than I can say for you. Your lack of exterior decorations is bringing down property values on the entire street. Move the vehicles now, or I'm calling the police and my lawyer," I said firmly. "Go ahead," she challenged. "The HOA has approved this temporary delivery for community improvement. Check your bylaws, Henry." I did call the police, and once again, Officer Reynolds responded. He seemed increasingly concerned about the pattern he was seeing. This time, He spoke to the truck driver directly and ordered him to move the vehicle immediately, which he did. Brenda was furious, but couldn't override the officer's authority. As I was finally able to back out of my driveway, Brenda approached my car window. "You've just made a serious enemy, Henry," she hissed. "I hope you're prepared for what comes next." I spent a tense Christmas with my family, distracted by Brenda's threat. My parents noticed my preoccupation, and after dinner I explained the situation to them. My father, a retired judge, listened intently before offering his perspective. "Son, this isn't just harassment, it's a calculated attempt to drive you out of your home," he said gravely. "I've seen cases like this before. She wants you to get frustrated enough to sell and leave." "But why?" "I've never done anything to her," I protested. "Sometimes it's not about you personally. Some people just need to exercise control over others. The HOA gives her a mechanism to do that legally to a point, but she's clearly crossing lines now." By January 2024, the situation had escalated further. Now Brenda was not only blocking my driveway regularly, but had also initiated a series of punitive HOA inspections of my property. I received notices for violations I couldn't possibly have committed, like having a prohibited plant species that wasn't even on my property, or unapproved exterior lighting that had actually been installed by the previous homeowner and approved years before I moved in. Each violation came with a fine, and they were adding up quickly. I was now paying hundreds of dollars monthly for fabricated infractions while still dealing with the driveway blockages several times a week. In February, I installed security cameras covering my driveway and the street in front of my house. The footage captured Brenda systematically blocking my driveway, often in the early morning hours when she thought I wouldn't notice until I needed to leave. Several times, the video showed her checking my house first to see if my lights were on, then deliberately positioning her vehicle to maximize obstruction. With this evidence in hand, Gabriella filed for a temporary restraining order. We appeared before Judge Melissa Hartman at the Fairfield County Courthouse on February 28th. Brenda showed up with her own attorney, a slick corporate type named Victor Preston, who specialized in HOA law. Judge Hartman reviewed our evidence carefully, particularly the video footage showing the pattern of deliberate obstruction. "Mrs. Wilson, do you have an explanation for why your vehicle is repeatedly parked blocking Mr. Fitzgerald's driveway?" the judge asked directly. Brenda put on her most innocent expression. "Your Honor, I've occasionally parked there briefly while dropping things off at other neighbors' homes. Our community has limited street parking, and I've never intentionally blocked anyone's access." Her lawyer jumped in. "Furthermore, Your Honor, the Oak Ridge Estates HOA has governance over parking regulations within the community. This is essentially an internal matter that should be handled through HOA dispute resolution channels." Judge Hartman wasn't buying it. "Mr. Preston, HOA authority does not supersede basic property rights or access to public thoroughfares. The video evidence clearly shows a pattern of deliberate obstruction." She turned back to Brenda. "Mrs. Wilson, I'm granting a temporary restraining order prohibiting you from parking within 15 feet of Mr. Fitzgerald's driveway or otherwise impeding his access to public streets. Violation of this order may result in contempt charges. Do you understand?" Brenda's face reddened, but she nodded curtly. "Yes, Your Honor." For about 2 weeks, Brenda complied with the restraining order. My driveway remained clear, though I often spotted her watching my house from her front window. The HOA violation notices continued to arrive, however, each more ridiculous than the last. Then, in mid-March, she found a loophole. Instead of parking her own vehicle across my driveway, She began coordinating with her friends and family to use their vehicles instead. One morning, it would be her daughter's Honda Civic, the next her friend's Toyota Highlander. Since the restraining order specifically mentioned her vehicles, she technically wasn't violating it. Gabriella and I returned to court to amend the restraining order to include vehicles operated by Brenda's agents or associates. But Judge Hartman was on vacation, and the substitute judge was less sympathetic to our case. He denied our motion, saying we hadn't provided sufficient evidence that these other vehicles were connected to Brenda. By April, I was at my wits' end. The daily stress was affecting my work, my health, and my overall quality of life. I'd installed additional cameras and collected license plate information from every vehicle that blocked my driveway, meticulously building a case showing their connections to Brenda. I'd also started parking my own car on the street overnight when possible, just to ensure I could leave when needed. One rainy morning in late April, I had an emergency call from my biggest client needing immediate assistance with a system crash. As I rushed outside, I found a large commercial landscaping truck completely blocking not just my driveway, but extending across my front lawn as well. The company name on the side read Wilson Property Management, a business I later discovered was owned by Brenda's brother. No one was in the truck, and when I went to Brenda's house, no one answered. I called the police, and this time a different officer responded. He was less familiar with the situation and spent nearly an hour trying to locate the truck's owner before finally calling a tow service. By then, my client had found another consultant to handle their emergency. That evening, as I was documenting the incident, I noticed something on the security footage I hadn't seen before. The video clearly showed Brenda directing the truck driver where to park, pointing specifically at my driveway and making a blocking gesture with her arms. This was direct evidence of her violating the spirit of the restraining order by proxy. Gabriella was ecstatic when I shared the footage. "This is exactly what we needed, Henry. She's on camera directing someone else to block your driveway. This is a clear violation of the restraining order's intent, and we can argue it constitutes criminal obstruction." We filed an emergency motion and were back in front of Judge Hartman 2 days later. This time, Brenda's attorney looked significantly less confident. "Your Honor," Gabriella argued, "my client has endured over 6 months of systematic harassment from Mrs. Wilson, who has used every means at her disposal to restrict his freedom of movement and right to access public roads from his property. The video evidence clearly shows her orchestrating this most recent incident, deliberately circumventing your order while violating its spirit." Judge Hartman watched the video carefully, then turned to Brenda with a stern expression. "Mrs. Wilson, this court does not look kindly on attempts to circumvent its orders through technicalities. Your actions demonstrate a clear intent to continue harassing Mr. Fitzgerald despite my previous ruling." She amended the restraining order to include any vehicle directed, requested, or influenced by Brenda Wilson to park in a manner that obstructs access to Henry Fitzgerald's property. She also ordered Brenda to pay $5,000 in damages and legal fees. I thought this would finally end the nightmare. I was wrong. By May, Brenda had escalated her campaign against me through the HOA itself. As a board member, she pushed through a series of new community regulations that seemed specifically designed to target me. One new rule limited home-based businesses to operating between 10 o'clock a.m. and 4 o'clock p.m. hours that would make it impossible for me to accommodate my clients' schedules. Another prohibited excessive vehicle movement on community streets before 8 o'clock a.m. or after 6 o'clock p.m., with violations subject to $250 fines. During this time, the driveway blocking incidents decreased, but didn't stop entirely. Now, when it happened, the vehicles were always owned by people with no obvious connection to Brenda delivery trucks that had mistakenly parked there, visitors to other homes in the neighborhood, or service vehicles that just happened to need that particular spot. Each time, I documented the incident, and though I couldn't prove Brenda's involvement directly, the pattern was unmistakable. The obstruction always occurred when I had important meetings or deadlines, information she could only have obtained by monitoring my comings and goings, or possibly accessing my online calendar, a disturbing thought that led me to change all my passwords and strengthen my home network security. By summer, my case file had grown enormous. Gabriella and I had compiled over 200 documented incidents of driveway obstruction, 47 baseless HOA violation notices, and evidence of Brenda's direct involvement in at least 30 cases. We also discovered, through public records requests, that Brenda had filed complaints against 6 other homeowners who had subsequently sold their properties, 3 of which were purchased by her relatives or close friends at below market values. This is a pattern of organized harassment designed to manipulate property ownership in the community, Gabriella explained during one of our strategy sessions. She's essentially using the HOA as a weapon to force out homeowners she doesn't want as neighbors, then bringing in people from her own circle to replace them. In July, things took an unexpected turn. I received an anonymous email from someone claiming to be a former HOA board member who had resigned because of Brenda's tactics. The email contained financial records showing that under Brenda's influence, HOA funds had been diverted to services provided by companies owned by her family members, including the landscaping company that had blocked my driveway in April. Gabriella advised caution. This could be valuable evidence of a larger scheme, but we need to verify its authenticity before using it. We hired a forensic accountant who confirmed that the records appeared genuine. Over the past year, the HOA had paid Wilson Property Management over $120,000 for services that were either never performed or grossly overcharged. Similar patterns existed with 3 other companies connected to Brenda's family. Armed with this information, we contacted the Fairfield County District Attorney's Office. Initially, they seemed hesitant to get involved in what they viewed as a neighborhood dispute, but the financial records caught their attention. White-collar crime investigator Detective Sarah Martinez was assigned to review our evidence. After several weeks of investigation, Detective Martinez informed us that they were opening a formal investigation into Brenda Wilson and the HOA board for possible financial fraud, corruption, and criminal harassment. She requested all of our documentation, which by now filled 3 large storage boxes plus several gigabytes of digital files. In August, just as the criminal investigation was gaining momentum, Brenda seemed to back off entirely. My driveway remained unobstructed for nearly 2 weeks, the longest stretch of peace I'd had in almost a year. The HOA violation notices also stopped arriving. I was cautiously optimistic that perhaps she'd finally realized the seriousness of her situation. Then, on a Sunday morning in late August, I woke to find not just my driveway blocked, but my entire front yard filled with vehicles. There were 5 cars and trucks parked on my lawn, across my driveway, and extending onto the sidewalk. My property had essentially been turned into an impromptu parking lot. Neighbors gathered to stare at the spectacle as I called the police. Officer Reynolds arrived quickly, having become familiar with the ongoing situation. He immediately began documenting the scene and running the license plates of the vehicles. Every single one of these vehicles is registered to someone in Brenda Wilson's family, he informed me after checking the records. This isn't just harassment anymore, Henry. This is criminal property damage and trespassing. While we were talking, Brenda emerged from her house and walked over, a smile on her face. "Is there a problem, officer?" she asked innocently. "I'm hosting a family reunion today and we needed some overflow parking." Officer Reynolds turned to her with a stern expression. "Mrs. Wilson, you know very well this is Mr. Fitzgerald's private property. These vehicles are trespassing and causing damage to his lawn. I'll be issuing citations to each vehicle owner, and they'll all need to be moved immediately." "I'm sure Henry doesn't mind helping out a neighbor in need," she replied, still maintaining her facade of innocence. "I'd had enough." "This has to stop, Brenda. It's been almost a year of constant harassment. What did I ever do to deserve this?" Her smile finally dropped, and for the first time, I saw the raw anger behind her carefully maintained veneer. "You don't belong here," she hissed, keeping her voice low enough that only I could hear her. "This community has standards, and people like you who work from home, with your clients coming and going at all hours, your packages being delivered daily, you're bringing down property values for everyone. I've managed to clear out 6 other undesirables from this neighborhood, and you're next." Officer Reynolds caught enough of her tirade to realize something significant was happening. "Mrs. Wilson, I'm going to need you to repeat that statement at the station. We've had numerous complaints about your behavior toward Mr. Fitzgerald and others in this community." What happened next shocked everyone. Brenda turned to walk away, and when Officer Reynolds moved to stop her, she shoved him forcefully, causing him to stumble backward. He quickly regained his footing and informed her she was under arrest for assaulting a police officer. As she was being handcuffed, Brenda began screaming accusations at me, claiming I'd manipulated the situation to frame her. Neighbors watched in stunned silence as she was placed in the back of the police cruiser, still hurling threats and obscenities. The vehicles on my property were all towed at their owner's expense, and I was left with deep tire tracks across my once pristine lawn. The physical damage was the least of my concerns, however. Brenda's mask had finally slipped, revealing the extent of her malice toward me and others in the community. Following her arrest, the district attorney's investigation accelerated. Detective Martinez obtained warrants to search Brenda's home and personal records, where they discovered meticulously kept notes on several homeowners she had targeted, including me. She had recorded our daily routines, identified what she considered vulnerabilities in my case, my need to leave home for client meetings, and documented her strategies for driving us out of the neighborhood. Even more disturbing, they found evidence that she had somehow gained access to my home while I was away, likely to plant recording devices. A sweep of my house by security professionals confirmed this suspicion. They found 3 small listening devices, one in my home office, one in my living room, and one in my bedroom. This discovery elevated the case from harassment to criminal stalking and illegal surveillance. Brenda remained in custody, denied bail due to the severity of the charges and the likelihood she would continue her harassment if released. In September, a grand jury indicted Brenda on multiple felony charges: criminal harassment, stalking, illegal surveillance, assault on a police officer, fraud, and criminal obstruction. The evidence against her was overwhelming, bolstered by testimony from other homeowners who came forward after her arrest to share similar experiences of targeted harassment. Throughout the fall, more details emerged about Brenda's operation. She had effectively turned the HOA into her personal fiefdom, using her position to enrich her family through fraudulent contracts, while systematically targeting homeowners who didn't fit her vision for the community. The other board members claimed they had been manipulated or intimidated into complying with her demands, though investigations revealed some had benefited financially from the arrangement. By December 2024, as the case prepared to go to trial, Brenda's attorney approached the district attorney with a plea offer. After negotiations, she agreed to plead guilty to criminal obstruction, harassment, and fraud in exchange for the other charges being dropped. On January 15, 2025, almost exactly 400 days after she first blocked my driveway, Brenda Wilson stood before Judge Richard Collins for sentencing. The courtroom was packed with current and former residents of Oak Ridge Estates, many of whom had submitted victim impact statements describing how her actions had affected their lives. When it was my turn to speak, I approached the podium feeling a strange mix of emotions: relief that this nightmare was finally ending, but also sadness that one person's need for control had caused so much unnecessary suffering. Your Honor, for 400 days, I lived with the constant stress of not knowing whether I could leave my own home without obstruction. What began as a simple parking issue revealed itself to be part of a systematic campaign to drive me and others from our homes for no reason other than that we didn't fit Mrs. Wilson's personal vision for the neighborhood. The psychological toll of knowing someone was monitoring my movements, listening to my private conversations, and actively working to disrupt my life and livelihood has been immense. All I ever wanted was to live peacefully in my home and do my work without interference. Judge Collins listened attentively to all the testimony before addressing Brenda directly. Mrs. Wilson, the court is troubled by the calculated nature of your actions and your abuse of the HOA's authority to harass and intimidate your neighbors. What you have done goes far beyond neighborhood disputes or overzealous rule enforcement. It was a deliberate campaign to control property ownership in your community through intimidation and illegal tactics. He sentenced her to 8 months in county jail for criminal obstruction, with additional suspended sentences for the other charges contingent upon her completing 5 years of probation, paying substantial restitution to all affected homeowners, and being permanently barred from serving on any HOA board or similar community governance organization. As Brenda was led from the courtroom, I felt no satisfaction or vindication, only relief that the ordeal was finally over. In the aftermath of Brenda's conviction, Oak Ridge Estates underwent significant changes. The entire HOA board resigned or was removed, and a new board was elected with strict bylaws limiting the power of any individual member. An independent auditor was brought in to review all HOA finances, resulting in the recovery of nearly $200,000 in misappropriated funds. The community also established a homeowner advocacy committee to ensure that HOA rules were enforced fairly and consistently, with transparent processes for addressing violations and resolving disputes. I was asked to join this committee, but declined, preferring to focus on rebuilding my business, which had suffered during the long months of disruption. By spring 2025, life in Oak Ridge Estates had returned to something resembling normalcy. My lawn had been professionally restored, and I'd enhanced my home security system to ensure no one could ever again invade my privacy so easily. My driveway remained blissfully unobstructed, allowing me to come and go as needed for my now thriving business. One sunny Saturday in April, I was working in my front garden when a moving truck pulled up to Brenda's house. A young couple emerged, Grace and Michael Chen, both doctors at the local hospital. They approached me cautiously. "Hi, I'm Grace, and this is my husband, Michael. We're moving in next door," she said, extending her hand. "The real estate agent told us a little about what happened here. It sounds like it was pretty awful." I shook her hand, then Michael's. "It was challenging, but it's over now. The community has changed for the better because of it." Michael nodded thoughtfully. "We were hesitant about buying in an HOA community because we've heard horror stories, but the new board seems very different." "They are," I assured them. "Transparency and fairness are the priorities now. It's a good neighborhood with good people. One bad actor doesn't define a community." We chatted a while longer before they returned to their moving truck. As I watched them begin unloading, I felt a sense of closure. The 400 days of harassment had been a nightmare, but they had also revealed the strength of our community when faced with adversity. That evening, I sat on my front porch with a glass of wine, watching the sunset. My phone buzzed with a text from Gabriella, who had become a friend through our long legal battle. "Just heard Brenda's appeal was denied. Justice system got it right for once. How are you doing?" I typed back. "New neighbors seem nice. Community is healing. I can leave my driveway whenever I want. Life is good." And for the first time in a very long time, it truly was. Later that week, I attended the first meeting of the reformed HOA. The atmosphere was notably different, open, collaborative, and focused on genuine community improvement rather than punitive enforcement. Gerald Thompson, the former president who had enabled much of Brenda's behavior, had moved away shortly after her arrest, reportedly to avoid potential legal consequences for his role in the scheme. The new board president, Maria Rodriguez, opened the meeting by addressing the elephant in the room. "We're all aware of the damage that was done to our community by the previous administration. Our goal now is to rebuild trust and ensure that the HOA exists to serve all homeowners, not to control them. To that end, we've drafted a new charter that significantly limits the board's authority and requires transparency in all decisions." The new charter included provisions requiring multiple board members to approve any violation notice before it could be issued, established an independent appeals process for disputed violations, required competitive bidding for all service contracts, and mandated quarterly financial audits by an outside firm. Most significantly, it explicitly prohibited board members from issuing violations or making decisions affecting properties adjacent to their own, to prevent the kind of targeted harassment I had experienced. After the meeting, several neighbors approached me to express their support. Many admitted they had been aware of some of Brenda's tactics, but had been afraid to speak up for fear of becoming targets themselves. The case had exposed not just one person's wrongdoing, but also how easily community governance structures could be weaponized when members failed to stand up against abuse. In June 2025, I received an unexpected letter from the county jail. It was from Brenda. My first instinct was to throw it away unread, but curiosity got the better of me. "Mr. Fitzgerald," it began formally, "as part of my rehabilitation program, I am required to make amends to those I have harmed. I acknowledge that my actions toward you were inexcusable and caused significant disruption to your life and business. While I understand that words cannot undo the damage I caused, I wish to express my sincere regret for my behavior." The letter continued for several paragraphs, outlining how she had come to recognize the wrongfulness of her actions through mandated therapy and reflection. It seemed rehearsed and lacked genuine remorse, reading more like something written to satisfy a program requirement than a heartfelt apology. The final paragraph, however, seemed more authentic. I still believe that communities function best with clear standards and expectations, but I recognize now that my methods were not only illegal but morally wrong. No one has the right to make another person feel unsafe in their own home, regardless of their vision for the neighborhood. This is a lesson I have learned at great personal cost. I didn't respond to the letter. Some wounds were still too fresh, and I questioned the sincerity of her words. Instead, I focused on moving forward with my life and contributing positively to the community's recovery. By October 2025, exactly 2 years after Brenda first blocked my driveway, Oak Ridge Estates had transformed. The toxic atmosphere had dissipated, replaced by a genuine sense of neighborly cooperation. Property values, which had temporarily dipped following the scandal, had rebounded and even increased as the community's new governance approach attracted homebuyers who valued transparency and fairness. The Chen family next door had become good friends. Their twin toddlers often played in my yard, and we regularly shared meals on our adjoining patios. Michael had joined the HOA board, bringing his thoughtful, measured approach to community issues. One evening, as Michael and I were grilling on my back deck, he asked me a question I'd been pondering myself. "You ever wonder why she targeted you specifically? Was there something that triggered her behavior?" I took a moment before answering. The detective who investigated her records found notes suggesting she saw my home-based business as disruptive to the residential character of the neighborhood. Apparently, the occasional client visits and package deliveries offended her sense of what our street should be. Michael shook his head in disbelief. "That's such a minor thing to build such elaborate harassment around." "I think it was never really about me or my business," I replied. According to the psychologist who evaluated her for the court, Brenda has narcissistic tendencies and an obsessive need for control. The HOA gave her a legitimate structure to exercise that control, and when people didn't comply with her vision, she escalated to illegal tactics. I was just one of several targets. Still, 400 days of blocking your driveway, that's a special kind of dedication to harassment, Michael noted. "The scariest part is how systematic it was," I said. "The records they found showed she kept detailed notes on my schedule, identified exactly when blocking my driveway would cause maximum disruption, and coordinated with others to maintain the harassment even when legal action should have stopped it. If she put that much effort into something positive, imagine what she could have accomplished." In November, I received notification that Brenda would be released in December, having served her full 8-month sentence. The news brought a momentary return of anxiety, but her probation terms prohibited her from returning to Oak Ridge Estates or contacting any of the residents she had harassed. She would be living with her sister in Vermont, far from Connecticut. On the 1-year anniversary of her sentencing, I received a call from Detective Martinez, who had maintained contact throughout the case. "Thought you'd want to know," she said. "The State Attorney General's office is using your case as part of a new initiative to create guidelines for HOA governance. They're developing legislation that would establish clearer boundaries for HOA authority and better protections for homeowners against abuse of power." "That's good to hear," I replied. "If something positive can come from all this, maybe it was worth it." "You did everything right, Henry," she assured me. "You documented everything, followed proper channels, and persisted even when the system initially failed you." Not everyone would have had the resources or determination to see it through. Her words made me reflect on how privileged I had been in my ability to fight back. I had the financial stability to absorb the cost of legal representation, the flexibility of self-employment to attend countless meetings and court appearances, and the technical knowledge to set up comprehensive surveillance of my property. Many others facing similar harassment might have been forced to give up and move away, which was exactly what Brenda had wanted. This realization led me to establish a small non-profit organization in early 2026, dedicated to providing resources and support for homeowners facing HOA disputes. We offered guidance on documentation, legal referrals, and in some cases, financial assistance for those unable to afford representation. The work was fulfilling, giving purpose to the difficult experience I had endured. By spring 2026, life had truly moved on. Brenda Wilson's name rarely came up in community discussions anymore, and when it did, it was as a cautionary tale rather than an open wound. The new HOA leadership had proven its commitment to fairness and transparency, and the community had healed. As for me, my business was thriving, my home was peaceful, and my driveway remained blissfully unobstructed. The 400 days of harassment had changed me. I was more assertive in standing up for myself and others, more aware of how governance structures could be abused, and more appreciative of the simple freedom to come and go from my home without obstruction. On a warm May evening, as I returned home from a client meeting to find my driveway clear and welcoming, I reflected on the journey of the past 2.5 years. What had begun as a simple act of petty harassment had evolved into a complex legal battle that ultimately strengthened both my personal resolve and the community's governance. I parked my car, walked up my front path, and paused to appreciate the simple pleasure of unimpeded access to my own home. Some lessons come at a high price, but their value endures long after the cost is paid. In my case, the lesson was clear. Justice may be slow, but with persistence and proper documentation, it eventually arrives even for something as seemingly trivial as a blocked driveway.